A lot of you are asking who leaked Alex Jones's deposition. The reality is,
probably nobody.
this is probably going to be my last law vlog on the Alex Jones deposition until further developments. A number of you are asking who leaked the deposition, how did it get on YouTube, what's going on, etc, etc. And it's a good opportunity to talk about the deposition process in general. I am Viva Fry, a Montreal litigator turned YouTuber, and what I'm going to break down for you is the procedure as relates to depositions purely from a Quebec law perspective, because that's all I know on a professional level. Now, the procedure may be very similar in other provinces and in the States, but the big caveat—
this is not legal advice. I'm not giving you legal advice. If you need legal advice, consult with an attorney.
I'm just going to explain in broad terms how the deposition process works, and people can apply these principles mutatis mutandis to whatever the proper procedure is in the jurisdiction that you live. Depositions are also known as examinations. They're also known as discoveries. The purpose of a deposition, examination, or discovery is just that. It's to examine a witness on their story. It's to discover the opposing party's story. Bear in mind, the purpose of a deposition is not always just to catch the other party in a lie, contradiction, or whatever. Sometimes you genuinely want to discover, you want to explore what the other party's position is about. So you conduct these things called depositions, where you sit down in a room with the party and you examine them on their story. You may try to contradict them. You may try to ask them questions on your own exhibits. In Quebec, examinations, depositions, discoveries, there's something called— what's the word I'm looking for? Yes, that's right. There's something called an implied undertaking of confidentiality, meaning that when you conduct the examination, the deposition, it is not public right away. It is not necessarily public. There is what the Supreme Court of Canada has called the implied undertaking of confidentiality, which means that you have to keep it confidential until such time as it is filed in the court record. And bear in mind, what that means is you conduct the examination, you ask all the questions, you file exhibits during the examination, ask the witness or the party questions on the exhibits. You then receive the transcribed notes of the deposition and you decide what to do with it. If the examination went terribly, you may choose not to file it in the court record because it's not going to help your case. If the deposition went smashingly well and you caught the witness or the party in flagrant lies, you would then file the deposition in the court record. And in theory, it is public insofar as the court record is itself public. People can go to court, ask for a court file, and see what's in the court file. And it is the party who conducted the deposition's choice as to whether or not they want to file it in the court record. That is to say that the other party can't decide to file your deposition in the court record because it went so well for their client. What do I think happened with Alex Jones's deposition? Plaintiff's attorneys conducted the examination. They decided to file it in the court record, and once it was filed in the court record, it became public, and they decided to publish it online on YouTube. I don't think anyone actually leaked the deposition. I don't think Alex Jones's attorneys leaked or filed the deposition because it was never their deposition to file, assuming the Texas rules operate the same way as the Quebec rules. And let me just clarify what that means. It is the party who conducts the examination's option to file or to not file the examination in the court record. Taking Alex Jones as a concrete example, plaintiff's attorneys alone could decide to file or to not file Alex Jones's deposition. It's not as though Alex Jones through his attorneys could say, hey, I want to file that deposition because I think it went so well for me. And in Quebec, depositions can be filed in whole or in part. If you don't want to file a 500-page deposition because there's only 3 pages you want, you can decide to file those 3 pages. The other party can in turn say, whoa, those 3 pages can't be dissociated from any number of other pages, so it has to be filed with those other pages which set the context for the part that was filed. In my practice, if I conducted an examination, it was for the purposes of filing it, and if I filed it in its entirety because I think it looks dishonest on its face to only file certain excerpts because it looks like you're trying to hide something else that went on in the rest of it that didn't quite suit your file. And what's going to happen next in the Alex Jones defamation lawsuit, assuming Texas procedure operates the same way as Quebec procedure, now Alex Jones and his attorneys should have the option or the opportunity to examine the plaintiffs. And bear in mind, it is plaintiffs suing Alex Jones for damages, which means that plaintiffs are going to have to prove certain things in order to succeed on their claim for defamation. The most important thing of which is going to be actual damages. So Alex Jones and his attorneys are going to have the opportunity to test the story of the plaintiffs. That should be the order of how things go, but now you sort of understand the whole process of deposition, discovery, examinations. It's actually quite fascinating. It's quite exciting as far as the practice goes, if you can stomach that sort of stress. Oh yes, and one last thing. People in the comment section are talking about the evidence made during the deposition. This is something that's a little conceptually difficult for people to fully grasp. There is no evidence in a deposition. There are exhibits. There are documents that are filed that are given little numbers, R1, R2, R3, or in Alex Jones's case, AJ1, AJ2, AJ3. Those documents are not evidence. They do not constitute evidence until they are submitted to a judge during a trial, and the judge accepts the documents as evidence. A document, a photograph, a video, evidence is only made once a judge accepts it as evidence. All that we have from Alex Jones's deposition are clips, videos, documents, whatever. No evidence has been adduced. It will be adduced at trial based on the rules of admissibility of evidence at trial. Be sure to like, share, subscribe, hit the notification bell, spread the word, share my channel. I've got a good fishing video coming this weekend. Weekdays are going to be for law vlogs, weekends are going to be for the fun stuff, and now you know your vlog. Peace out. Boom!